Hello viewers, have you ever wondered how the law can be stretched in order to keep up with the technological advancements that are occurring in each and every day? Well, if you have, join me and my colleagues as we discuss on patent protection for computer-related inventions. We are University of Zimbabwe students and we are going to be looking at this topic in greater detail. Thank you. Well, viewers, we're going to have Ndakaro explaining to us the basic introduction to what patents are in terms of our law, as well as what computer-related inventions can be understood as. So, Ndaka, can you take us through?
Thank you, Wesley. So, I will just focus on the introduction of our topic. And the topic, as has been said, is patent, that's intellectual property protection of computer-related inventions. And I'm going to define some keywords and some phrases from the topic. I'm going to define the word patent. I'm going to define the word computer-related invention, and I'm also going to define the word invention. Mm-hmm. What do we mean when you say someone has invented a product? Mm-hmm. So according to the Patents Act, of 2002, they've defined a patent as an exclusive rights that are granted by the Patents Office. And this is evidenced by a patent certificate, which allows the inventor to make and sell a product for a period of 20 years in case of our laws in Zimbabwe. Okay. So we are saying for the whole period of 20 years, no one is allowed to use that product, to sell it or use it in any other form, except leave is granted by the inventor. So I'm also going to talk about computer-related inventions. What are they? If we're talking about computer-related inventions, this comprises of all the products that are related to computers networks, and also programmable apparatus. And I can list a lot of technologies that have been invented in the past years that are related to computer inventions. So I can talk about quantum computing, robotics, cyber security, bioinformatics, among others. So I'm saying, I'll just end here, okay, so that I'll give a chance to my colleagues to continue shedding light on this topic. They are going to describe, to discuss on benefits of computer-related invention.
Well, that is very good, Ndaka. And we also want to see how the law is protecting these inventors, because you find the time it's not a very common thing in Zimbabwe. Yes. So we're going to have Tinai give us a background, some background information on computer-related inventions and how the law has been coined to protect those individuals. You know, viewers, that Ndaka has laid us a foundation for us so that we may understand more on which is to do with patent protection for computer-related inventions. We're going to have Tinai take us deeper and give us some background information where these things actually started. Did it start with computer-related inventions, or which area of study is issues of patents most related to?
Okay, thank you for that. I think moving on from what Ndaka has said, when we look at these patent laws and when we look at our intellectual properties, we are looking into a situation whereby we as a country, we as Zimbabweans, we have got our indigenous knowledge and our indigenous systems, which must be protected by certain laws. This is best described or defined in two ways, which are intellectual properties, which can be registered, intellectual properties, which can be promoted until they get to a stage of registration. We also look at who can apply for this intellectual property. There was a cry by the authorities that Zimbabweans are not being enthusiastic enough or being innovative enough to go and apply for these patent laws in terms of the protection of their intellectual properties. So in a situation like this, we see countries outside us. I've got a few statistics here, like of course, because this is in Zimbabwe, we might have about 81 participants, but we are looking also at a situation where we're having a lot of participants from outside, like from Kenya. That's 10 from South Africa, 4 from Swaziland, 2 from Sweden, 2. These are not all the statistics that have been captured. But if you look at this, this is a very small number, 81 participants compared to a whole lot of people that are in this country. Moving on in terms of why should we even at all we have these intellectual property laws. This is to protect us as a nation, to protect us as Zimbabwe, so that as Zimbabwe on the global market, also on the global legal network, we are recognized as an independent country, as we can identify ourselves on that map, because we have our laws which guards, which defines our property rights. So the importance of these rights is that at the end of the day, they will protect us and make us move in terms of our cultural development, and in terms of our economic development, and in terms of other spheres of development that we can have a look at.
Okay. That is very insightful.
Yes.
That is very insightful tonight.
Okay.
So I think we've been given a very sufficient background information. We now understand how it's linked with intellectual property rights, and how Zimbabweans, most of them, can say reluctant, but they are not too innovative at the moment. But we know that in as much as our technology is shifting, the law is following behind, trying as much as it can to protect people. All right. Now, Tina has given us a very sufficient background information on what intellectual property is. So we have Christabel, who's going to give us the relevant intellectual property rights that are there to protect people who are computer inventors. So take us through, Christabel.
Thank you, U.Z. So I'm going to explain which rights are relevant to software protection.
All right.
So there are 4 intellectual property rights, and these include patents, trademarks, copyrights, and design rights.
All right.
So these 4 types are used to protect computer programs and software. So intellectual property rights are at the root of software industry, and innovations made in software products can be protected by patents, copyrights, trademarks, and design rights.
All right.
Right. So patents and copyrights, they provide the protection to software itself. Yes. So on the other hand, trademarks protect the names or symbols used to create a distinguishable identity in the marketplace. So there have been various discussions by the World Intellectual Property Organization, WIPO, which have resulted in generally accepted principle that patents, copyrights, trademarks should be used to protect software. So software patents are extremely valuable for the vendors, because they can protect the aspects of their product and other intellectual property laws cannot. So I'm going to explain on how patents can protect software.
Okay.
Right. So Article 27 of the TRIPS agreement, it makes patent protection available to inventions in all fields of technology, and only if they meet the minimum requirements, which is novelty, non-obviousness, and utility.
Okay.
Right. So the protection offered by patents is wider than that of the copyrights protection, as it extends to only specific expression, whereas patent protection, it extends to the underlying function of an invention. So because patents can offer a broader protection than copyrights, they tend to be more useful and more valuable if they can be obtained. So patents protect the intellectual idea that underpin the way software works. Then particularly in software-focused companies, where innovations, they can be quickly copied by competitors, the patents are often the most significant and transferable asset that software and e-commerce companies.
All right.
So an issued patent, it can be used to prevent others from copying, implementing the distinguished characteristics of a new website, and from utilizing an inventive aspect of a new software program.
All right.
Alright, so now that we have explained how a patent protects software, we'll now go to the copyrights.
Okay.
So the application of copyright protection for software products was established internationally via the World Trade Organization WTO agreement on trade-related aspects of intellectual property rights, TRIP.
Okay.
So in this case of software, the protection provided by copyright is basically on the source and object code, along with certain unique and original elements of the user interface. So furthermore, the protection of computer programs is afforded by the Copyright and Neighboring Rights Act, Chapter 26.05 here in Zimbabwe, which was enacted in November 2000, but this has not come into operation.
All right.
So the WIPO, the World Intellectual Property Organization 1996 Copyright Treaty, it provides that computer programs are protected as literal works within the meaning of Article 2 of the Berne Convention. So in wrapping up, I'll explain how the trademarks and design protect software.
All right.
Okay. So the trademarks, they protect the name of software, its logo and taglines, and it prevents competitors from using similar names. Right. So the design rights, they also protect software. How? The designs offer both registered and unregistered forms of protection for the way of things look. For example, the screen displays, the graphics, including GUIs, they can be protected by design rights. So however, as with trademarks, the technical aspects of software cannot be protected using design. So this is how trademarks, the patents, the copyrights, and the design rights protect software.
Oh, that is very insightful. Thank you so much, Christabel. So she's basically saying, if we have WhatsApp and I come up and I say I've invented my new application, it's what's down, I'm going to be arrested for if I've been in violation of intellectual property rights. Is that it?
Yeah, sure.
Oh, thank you so much. Now that Christabel has laid a very good foundation on the intellectual property rights that are there to protect computer-related inventions, Taro is going to take us through how these rights can be implemented and protected. So Taro, take us through.
Okay, let's see. So protecting one's intellectual property is a means to secure an economic advantage for one's business and to make sure that the computer-related inventions are defended. Intellectual property can be protected by documenting one's discoveries. In the information age, leaks are very frequent, we see. So while discoveries and innovations can't always be guarded against, they can be recorded as they occur. So I'll quickly move on to the next, and this is through the use of digital rights management or DRM systems. If your work is published online and accessible to users, some of those users may attempt to copy that property. Digital rights management protects your online assets with coding that does any or multiple of the following: limits the number of the times the window of time a user can access your work. It can restrict the number of devices your work can be accessed with, prevents users from editing, saving or copying your work. Next, we move on to opting for strong non-disclosure agreements. A non-disclosure agreement restricts any involved party from sharing information defined by the terms of the agreement. Drafting an NDA or a non-disclosure agreement strengthens your defenses against IPR violations like trade secret misappropriation, where an employee could share sensitive computer-related information with outsiders. Lastly, one can create strong access credentials. Guarding a secret requires proactive action. Unless you are the only person who knows the secret, without adequate security around a trade secret, courts won't be convinced that the secret was important enough to guard. So using strong credentials to restrict access to any valuable information, especially relating to intellectual computer-related inventions, proves to be very useful.
All right. Okay, so Tari, what are the advantages of intensive system softwares?
Okay, so intensive system software, this is a type of software created specifically for something. For example, pastel. It is comprised of a hardware, software, and a housing. So on the advantages of intensive system software, we have it enhances the quality and adds value on a design. For example, in construction industries, if a construction industry, for example, wants to build a building or to to construct a construction house? Well, firstly, they'll have to design the computer using that same software. So the software allows the constructors to perfect the building on the computer, so that when the building is on the ground, the mistakes are corrected and the building is perfect. So intensive system software, they can also be used for prototyping, can be used for simulation. It costs less, it is very cheap, and it is user friendly. It further improves network security management and achieving central management. Lastly, it improves data and log analysis.
Wow, thank you so much, Tarigo. That was a very good presentation. We knew that the law could spread to all those areas of study. Thank you so much. That is good.
You're welcome.
Okay, viewers, we are still learning. So, Tafadzwa, can you tell us what are the benefits of patents?
Okay, thank you, Wesley. I'm going to talk about the benefits of patents. With the advent of technology, many tech companies have resorted to getting patents for their products, right? So, I'm going to outline the benefits of patents. The benefits are mostly economical. So, the first benefit is that companies which take patents for their inventions, they have a monopoly over the market.
Oh.
Okay. So when we say monopoly, it means that they have exclusive control of the market, right? They're the only ones who are making the products, who are making the invention. So it means that they will control even the pricing.
Okay.
Well, let's say, for example, we have tech companies like Apple, right? So if Apple produces a new product, say an iPhone 14, and it gets a patent for that invention, it means that it is going to control the pricing. If it says the iPhone is 14,000, everyone is going to buy that iPhone for 14,000 because it has what? Exclusive rights over that patent. So you see, it's a very lucrative thing.
Yeah.
So moving on, we have another benefit of patents. Patents confer the benefits of preventing theft. In the advent of technology, right, many people try to circumvent the laws by stealing the inventions of other people. So to curb that disaster of inventions being stolen, right, what patents do is that when a person gets a patent for a certain invention, it means that the invention is now that person's own property, right? So it means that if any other person tries to steal, what happens is that they are going to be faced with several lawsuits. You can go and sue that person for stealing your invention, right? Okay. So you understand what I'm saying?
Yes.
So it means that thieves are not going to steal the patents, right? Moving on. Patents also. Okay. So as I was saying, patents confer the benefit of preventing theft. In the advent of technology, we have many cyber thieves. We have many other thieves who try to circumvent the laws so that they steal the inventions that they did not make. So in order to prevent that, the patents confer the exclusive use and rights over the property to the inventor. So this means that if a person tries to steal your invention or to pass off that invention as if they have made that, you can sue that person.
Okay.
Moreover, patents are important as they serve as a barrier for competition. This means that if any other people in the market try to make a similar product, you have two options. The first option is that you can go to the courts and you can do what is you can apply for disgorging them. Disgorging them means that while your patent is still being processed, while your patent application is still being processed, that person can be told by the court more of like an interdict to stop that, right? So the other remedy is that you can sue the person for infringement when a patent has already been issued. Okay. So you have these two remedies. So this means that as Zimbabweans or even the world at large, we're trying to curtail these thefts and to protect the rights of inventors. And overall, this has a ripple effect of making sure that the inventors are encouraged to do more innovation stuff, right? So that's all about the benefit of patents. And I would like to say that inventors out there are encouraged to invent because the law is protecting them. People should try to get these patents because they are readily accessible here in Zimbabwe. Unlike in other Roman Dutch jurisdictions like South Africa, where people cannot easily get patents for computer-related inventing. That's always.
Well, thank you so much, Tifanzo. This reminds me of one emotional movie that I watched whereby a young man invented an application called Unity. Next thing he knows, someone else published it in the name Unify. So this knowledge could come in handy for someone who wants to invent out there. Thank you so much. Okay, viewers, so Tafato has done a great job and is illustrated the benefits of patents. Now we need to know the approach of the law and the rigorous steps that the law needs to take to ensure that indeed there's been a violation of your rights. So Kunda is going to take us through.
I'll talk on how the court will test for the infringement, the damages that are to be paid, and how the court will calculate those damages. So the test for infringement of patent protection. So the owner of the copyright may institute litigation in the Intellectual Property Tribunal, the High Court or the Magistrate Court, and Section 52, subsection 1. The copyright owner may apply for an Anton Pillar order to secure this evidence. So the remedies available include damages, interdict, attachment, rendering of accounts, delivery of the infringement copies or articles used or intended to be used to make infringement copies. That is Section 52, subsection 2. The Act also lays down the guidelines for the determination of damages payables. Okay, so how the court would test for the infringement. So now I'm going to go in detail on how the court would test. So as stated earlier, not many infringement cases have as yet come to our court of Zimbabwe. So we refer to the English law, as obviously our law is plural. So we go back and look into how the English law deals with the calculation and with the infringement and how to calculate for the damages. So to establish infringement, the plaintiff, claimant must prove that his work was copied. And the court will ask the following question: is each such work original? Was there copying from that work? If there was copying, has a substantial part of that work been reproduced? And this is seen in the case of IBSCO Computers Limited versus Barclays Finance Limited, 1994. So now I'm going to go to the damages. Okay, so the damages have to be paid on how they are calculated. So I'll give a brief overview of the damage and state on how they are calculated later on. So according to Bainbridge David in the book Intellectual Property, the general rule is that damages should be assessed on the basis that the reward is intended to place the plaintiff in the position he would have been had the infringement not occurred. Because there is legal pluralism in our country, as I've said before, we are going to refer to the English law, as there are not many case laws in Zimbabwe on this issue. So the calculation of damages. When the claimant makes and sells a product, the damages should be assessed on the basis of the profits lost by the claimant as a result of the infringement. And 2, where the claimant grants licenses to others to exploit his inventions, damages should be calculated on the basis of the royalties the defendant would have paid had they acted legally. And the last thing is that where it is not possible to prove a normal rate of profit, a normal license royal damages must still be assessed. So, the implementing of damages to pay when someone is infringed protects actually the people who have made their computer-related inventions, so that they will be safe. They know that they are protected by the law.
Oh, okay.
Yes.
Thank you so much, Kundai. That was very insightful. She has covered on quantum of damages. I was also about to ask which court is the competent jurisdiction to deal with these matters, and I think you've addressed it.
Yes,
Thank
yes.
you so much. I'm most indebted to you. So we've learned that the courts in establishing these rights take a rigorous process of testing whether there has been infringement. So now Kumbi is going to take us through the critics surrounding that issue.
All right. Thank you. So I'm going to be touching on answering actually the critics that surround software inventions. So as we know, with software inventions, we have the hardware part and the software part.
Right.
And the critics are separate, but then it's still one component. So we look at questions like, we look at critics like there's a blockage of innovation, there's a blockage of improvement, and it limits so many people. Reason being, we all know the standard for which a thing can be patentable. We're looking at novelty, we're looking at novelty, we're looking at utility,
Yes.
right? As been alluded to by the other colleagues. So when we are in that situation, when we look at software and hardware, they also have to pass through that same criteria for them to be able to be patentable. But then we have people that try to then stop that because it stops so many things.
Okay.
Especially when we look at computer inventions. The first touchscreen was created in 1992. If that phone was patented, it meant that the next screen touch was going to be created in 2002. Already there's been a decade of a gap. There's no improvements because not every other person is not allowed to do so.
Oh,
Exactly.
okay, quite controversial.
Yes. We look at, especially when we're focusing on hardware, we look at companies like Apple. From 2000 to 2009, it had 52,000 patents. That alone tells us that if each one is made, maybe 10 or 100 are made in a year, they have got up to maybe 5 decades of patenting specific designs that cannot be improved. So when it comes to other people that would want to edit that, they do not have the liberty to do so because of the patent. You look at maybe the design, the convenience, or maybe the size, or even the way the battery works. Some people would complain, maybe it overheats, but then no one has got a way to fix that because already there's a patent in that. So that's where the problem comes, and yet these things are also protected. Then when it comes to software, if we're looking at how code and algorithms work, it is like how a house is built. There's a foundation and then the rest of the building. The design might change, but there always has to be a foundation when we're making a building. So once someone patents a building and said, I made a foundation, already everyone else cannot make anything because you need to build from that foundation. This is how code and algorithm work. So if you invent something, maybe a different application from WhatsApp, and it has so many different features, the fact that your root is a code that was already created, it's completely impatentable. Yes. So that's where we then see the problems of how things are slowed down because we need to wait for this company that has created something to have development. We even have our own, Zimbabwe might be a bit backward when it comes to computer inventions. We have one of our own, M.G. Kumbutsa. He made a drone in 2021. Very useful, it passed the utility check, right? But it did not pass the other two. It is not novelty, it is not new because so many other countries and so many other people have made their own drone as well. And its usefulness is also working for the same thing. It was meant to help with security. So already he cannot patent that. And he might even be sued because he has copied something that has been made by other people. So these are the problems that are faced when it comes to patenting software and hardware in computer engineering, in computer inventions. And there's a problem, especially when it comes to invention and improvement per se. We see that the whole world will be waiting for Apple and Samsung to release their models. Anyone else would try to make them. But because they are holding that area, they're holding that market, there's no improvement that comes outside them. So these are the critics, and this is how everything works.
Well, that was a very controversial issue, and I think a lot it has to be done. Those laws, in as much as they are protecting the rights of computer inventors, they must be, to a certain extent, be relaxed to allow for innovation and improvement. Thank you so much.
It is crucial to note that the Zimbabwean system follows a first-to-file system. that is the person who has invented an article should be quick to file his application for advertising. Otherwise, if somebody advertises first and someone applies first, the person who has applied first takes the precedence of having invented that particular article. The most feasible protection that is granted to a person who has got the right to intellectual property is that he can approach the courts and institute civil proceedings. There is an intellectual property tribunal that is a division of the High Court, or you can actually approach the High Court itself in seeking a relief as to a person who has infringed a particular right. And lastly, but not means the least, is a brief analysis of and evaluation of our country, Zimbabwe. Zimbabwe generally is a developing country, so there's also the technological advancement. So there is also need to craft laws that address the challenges that are brought about by the advancement of technology, or lest we wake up one day and find ourselves overtaken by events. Therefore, in upholding intellectual property rights, it is not only a compensation to the inventor, but it is also an incentive. It actually encourages others who are out there to take up the obligation of being involved in the processes of invention. Let me also say that much of the statistics, like many of my earlier presenters have alluded to, are actually coming from the foreign origin. The reason being that there is not much that has been happening on the local scene in terms of invention. So therefore, I would like to encourage people out there to do more in terms of the inventions of computer-related processes. Thank you.
Thank you so much, Terry. You've made a very good illustration. Indeed, it's taking us closer home to Zimbabwe. But I would also love to commend our very own legal system. We have implemented an integrated case management system, which is like software related. So that is a very good advancement of our law towards adapting with technological advancement. Okay, viewers, now that we've seen the Zimbabwean approach, we need to understand if it's really worth it to maintain the status quo. So, Sadeu, can you take us through?
Okay, so from the above analysis by my group members, it is indeed worth it to keep up with the current patent law. Why? Because firstly, maintaining the patent law comes up with enforcing a constitutional right, which is section 71 of the current constitution of Zimbabwe, which focuses on enforcing property rights. So if patent laws are enforced, then it is in line with the current constitution. Maintaining the current situation pertaining patent law is crucial because it prevents some undesirable social conduct which comes in the market pertaining computer developments such as theft. There's also a close link between patent law and competition in the computer development industry, which in simple terms can be characterized by a fact that patent laws aim to prevent the copying and also imitation of patent goods and also theft that complement competition policies in that they contribute to a fair market behavior. Also, it safeguards and it sets boundaries that have been built into the patent system to allow to generate patents only for those inventions which are most likely to serve for the public interest. As we know that due to the current computer innovations and technological advancements. People have been inventing so many softwares and systems, and some of these softwares, they are not for the public interest, they are not for the public good, and at the end people, they end up inventing softwares that are meant to meet with their own personal desires. So if goods are patented in line with the provisions of the law, the law enforcement agents, they are able to see whether the goods are good for the public interest, are they good for the public safety, or they are not. So by patenting goods, it means that the public is safeguarded from malicious goods which are meant for people's personal interest. Patents can be extremely valuable for small businesses that may be able to find investors willing to invest merely for rights to a patent. This is in line with Vision 2030, which enforces innovation. So patents, they help small businesses to be innovative by protecting their goods from other people or other inventors in the competition, which tend to copy them or to imitate them or hack their systems or damage their systems. So I think that is all we have on this of maintaining the current status quo regarding patent law.
Interesting. So I liked how you took a jurisprudential stance and reiterated that there's need for constitutional supremacy even when it comes to issues to do with community-related inventions.